Question 715. A franchise agreement establishes an agency, by which the franchisee is the agent of the franchisor. B. Employment arrangement, by which a franchisor treats a franchisee as an independent contractor. C. Legal right to operate a business under a common name and marketing plan. D. Both A and C. Correct answer is C. Legal right to operate a business under a common name and marketing plan. In a franchise agreement, a franchisee pays a fee for the right to conduct a business under a common name and marketing system. There is no employment arrangement and no agency is created. Question 716. All of the following statements about the escrow process are false, except A. Only a broker can be an escrow officer. B. The escrow officer acts as an arbitrator of disputes between the real estate commissioner and the buyer. C. An escrow is completed when the escrow holder is appointed. D. An escrow agency changes from a dual agency to a separate agency when the escrow requirements are satisfied. Correct answer is D. An escrow agency changes from a dual agency to a separate agency when the escrow requirements are satisfied. After escrow closes, escrow agents becomes an agent for either the seller or buyer. Question 717. Gift deeds conveying title to real property can sometimes be voided by A. The grantor's debtors. B. The grantor's creditors. C. Holders in due course. D. The state. Correct answer is B. The grantor's creditors. To evade creditors from attaching their assets, sometimes debtors will convey real property to friends or relatives by gift deed. Under these circumstances, there are legal safeguards which can enable creditors to have such gift deeds invalidated in court. Question 718. A second trust deed is distinguishable from a first trust deed by A. The title company. B. The date and time of the recording. C. The agreement of the parties. D. None of the above. Correct answer is B. The date and time of the recording. The priority of trust deeds is established by the date and time of recording. Question 719. Prohibiting the posting of a for sale sign on a property in a particular neighborhood is A. Not allowed, because it violates the U.S. Constitution. B. Allowed, because such signs can be disruptive. C. Not allowed, because realtors are an important component of the economy. D. Allowed, because it applies to everyone equally. Correct answer is A. Not allowed, because it violates the U.S. Constitution. Such a prohibition violates the First Amendment to the Constitution, which protects against unreasonable restrictions on free speech. Question 720. Which of the following refers to deferred maintenance? A. An apartment building with a leaking roof. B. An apartment building lacking good views from its windows. C. An apartment building with poor Wi-Fi reception. D. A commercial building with newly installed plumbing. Correct answer is D. A commercial building with newly installed plumbing. Deferred maintenance is an appraisal term relating to the physical deterioration of a building, not its lack of amenities. Failure to fix the roof could lead to water damage. Question 721. After a trustee's sale in a non-judicial foreclosure, any proceeds left over after paying off liens and foreclosure expenses belong to the A. Sheriff. B. Trustee. C. Foreclosed upon owner. D. Beneficiary. Correct answer is C. Foreclosed upon owner. In a trustee's sale, the costs of the sale and the debt owed to the foreclosing mortgagee are paid first. The surplus is distributed to owners of junior interests in order of priority. The mortgagor keeps any money that's left after paying the junior interests. Question 722. A non-physical incursion into another person's property would best be described as A. Nuisance. B. Encroachment. C. Eviction. D. Evulsion. Correct answer is A. Nuisance. A nuisance can be a legal term describing a situation or activity on a neighboring property which disturbs the owner's appropriate use or enjoyment. Examples: loud noises or bad odors. Question 723. The term used when an amendment is made to a will is A. Rider, B. Codicil, C. Devise, D. Probate. Correct answer is B. Codicil. A codicil modifies or revokes some provision of a will. Question 724. Which of the following would likely not be a good defense by a tenant against an eviction? A. The landlord's notice of eviction seeks more rent than is actually due. B. The premises are infested by termites. C. The tenant just lost his job. D. The tenant reported the property to the building inspector for safety violations. Correct answer is C. The tenant just lost his job. In order to evict a tenant, a landlord files an unlawful detainer lawsuit in court. Good defenses to the eviction include the landlord asking for more rent than specified in the lease terms, the property is in violation, the warranty of habitability, termites, or that the landlord filed the eviction action in retaliation for the tenant asserting a legitimate right, like reporting the property to the building inspector. If the court decides in favor of the tenant will not have to move, and the landlord may be ordered to pay the tenant's legal fees. Question 725. When title to a property is given to the lender as a guarantee against loan repayment, but the borrower maintains possession of the property, it is called A. Hypothecation, B. Collateral, C. Reconveyance, D. Qualified endorsement. Correct answer is A. Hypothecation. The property used in the hypothecation is the collateral. Rehypothecation is a practice followed in the financial markets, where a bank reuses the collateral pledged by its clients as collateral for its own borrowing. Question 726. A bank loan officer was referred a client by a real estate agent. Then, the loan officer sent the agent $100 in cash as a present. The agent should return the money because it is unlawful to accept it, under the provisions of A. RESPA, B. The Rumford Act, C. Regulation ZD. The agent can accept the money, there's no law against expressing friendship. Correct answer is A. RESPA. The Real Estate Settlement Procedures Act, RESPA, prohibits the giving and receipt of kickbacks for the acquisition of mortgage business from federally insured lenders.